I think India needs to do far more in terms of having in place enabling frameworks to protect the freedom of the press and to effectively implement the same. Yes, freedom of the press is already an integral part of the fundamental rights under the Constitution, but we require far more institutional mechanisms to further prop up this entire issue of freedom of journalists. This assumes more significance because the exact ambit of journalists has expanded massively. With the coming of COVID-19 and with more digitization coming in, internet has transformed almost all of us into becoming global authors, global broadcasters, and global transmitters of data. Therefore, every person who's got access to a computer or a communication device and the internet is effectively a journalist. That being so, it's very important that we must have in place adequate mechanisms which can help protect and preserve the right of the journalist to go ahead and report any particular event that they see. Of course, we have to realize that this right of journalists is not an absolute right. When I look at the Chapter 3 of the Constitution of India, I find that your fundamental right to freedom of speech and expression under Article 19 of the Constitution, specifically Article 19(1) of the Constitution of India, is not an absolute right. It is a relative right and can be subject to certain reasonable restrictions. These restrictions can be imposed by the government under various grounds. So there are various grounds under which reasonable restrictions can be imposed on the fundamental right to freedom of speech and expression under Article 19(1) of the Constitution. These reasonable restrictions are enshrined under Article 19(2) of the Constitution of India. And these grounds on which these restrictions can be imposed include the sovereignty, security, and integrity of India, friendly relations with foreign states, public order, decency, morality, or to prevent the commission of any cognizable offense. So the state has got the right to put in reasonable restrictions on the freedom of speech and expression, which will also mean the freedom of the journalists to write, to report anything that they see. So it's not an absolute unbridled freedom, but can be subject to certain reasonable restrictions. But whether those restrictions are indeed reasonable or not is something that ultimately tends to get decided by the judiciary of the country. If anybody or any journalist believes that the restrictions put on his fundamental right to freedom of speech and expression are restrictions which are not in accordance with the grounds of the Constitution, there's a constitutional remedy available. A writ petition can be filed under Article 226 of the Constitution of India before any of the high courts of different states. Alternatively, you can also file a writ petition directly to the Supreme Court under Article 32 of the Constitution of India. So it's all been a case where numerous challenges to various restrictions have come up before courts, and courts have amply clarified the particular law on this subject. Well, the new amendments that have come in the IT Rules 2021 are primarily aimed to deal with a much bigger issue of fake news. Now, the reality is that fake news is a huge animal. It's a huge elephant in the room, and you cannot just close your eyes to the elephant. Now, majority of the times, experts are of the opinion that the best way to go ahead and regulate fake news is to come up with dedicated laws in this regard. Let's look at the dedicated laws in this regard in Malaysia, in Singapore, in France, where you have dedicated provisions that if you go ahead and publish anything which is false news or fake information, then be prepared for the legal consequences. Till today, India does not yet have any dedicated law on fake news. On top of it, fake news itself does not find mention specifically under the digital law of the country, being the Information Technology Act 2000. But having said that, with more and more people becoming intermediaries and generating data in the form of network service providers, a need was felt by the government that the time has come that we must try to take appropriate steps by putting in appropriate due diligence parameters for intermediaries to comply with in order to reduce or potentially lessen the impact of fake news. And that's why First, the IT Rules 2021 got notified on the 25th of February 2021. They got further amended in October 2022. And the amendment was to the effect that the service providers and intermediaries shall not only inform their users about various kinds of content that they should not be uploading, hosting, posting, or sharing or transmitting, but they will also take reasonable steps to prevent their users from doing activities which are in contravention of the law. But then these amendments in 2022 got further updated, and these updated, amended, revised IT Rules 2021 have come into effect from 6th of April 2023. Now, these revised rules are important because these have now brought in a different new area of potential coverage under the rules, which is the area of online gaming and gambling. Having said that, we do find that a particular provision has been added of a fact-checking exercise that is sought to be introduced with respect to any information that belongs to or connects with or is associated with the business of the government. Well, the government has been very concerned that there's a lot of fake information pertaining to various ministries or governmental bodies or projects or initiatives, and that in order to determine whether they are fake or not fake, the government has said that let's now come up with a fact-checking unit that's going to be established by the central government, specifically the Ministry of Electronics and Information Technology. And vis-a-vis all information pertaining to the interest or the business of the government, this fact-check unit alone shall be the sole arbiter to decide whether the said information is false or inaccurate. If the said information is found to be false or inaccurate, then the said information shall be liable to be removed on an immediate basis by the concerned service providers from their respective platforms. So in a nutshell, for the first time, we now have a new kind of an arbitrator who will act on behalf of the government, who will look at all information in the public domain pertaining to the government, and who will then try to adjudicate whether the information that's available is indeed correct, accurate, inaccurate, or false. And once it so decides that some information regarding the government is false or inaccurate, then the service providers will have no choices but to instantaneously remove the same from the networks. So that's one big kind of addition that's been added under the IT Rules 2021, which have been amended and updated as on 6th of April 23. I think when a government decides to come up with a fact-checking unit, then effectively it's trying to say that the fact-checking unit alone will be the sole person to determine, or the sole legal entity to determine the accuracy or otherwise of any information pertaining to the government. Now, the problem is this is coming in quite kind of a sweeping language under the proposed new rules, Rule 3 of the IT Rules 2021. Now, there are no apparent checks and balances. We don't know what will be the basic parameters which are going to be used by the fact-checking unit for the purposes of determining the accuracy or inaccuracy or falsity of any government-related information. We don't know who will be part of these fact-checking units, whether they'll be distinguished individuals with distinguished service careers in journalism or similar kinds of a field. We also don't know the processes and procedures that are going to be adopted by the said fact-checking unit. So effectively, in the absence of crystal clear provisions, it appears that the fact-checking unit could be nothing but an extension of the mindset or the thought process of the government, which effectively means that if you are an investigative journalist and you are investigating against something which is either being not done properly or not in accordance with norms, your information can be designated as fake information, because here it's the government body which will determine what information that you are producing or publishing or transmitting is fake or not. I think there's a lot of work that we need to work in this regard. Well, the fact-checking unit can be seen as a reasonable restriction on the freedom of speech and expression under Article 19 of the Constitution, but the problem is it requires more embellishments. It requires more clarity on the checks and balances that will have to be kept in mind while we go ahead and implement such fact-checking unit. And mind you, how much fact-checking will this unit be actually able to do? That's a big question, because internet is not just located within India. It's located all over the world. So people may be sitting outside the territorial boundaries of the country and may still be publishing content which may be then designated as fake information by the fact-checking unit. But even if they so designated, does it mean that all intermediaries in every part of the world will go ahead and remove the same? I have my quick doubts on the same for the very simple reason that brings in far more complicated issues of not just internet attribution, but also of internet jurisdiction. Because the law in India typically can only be applicable within the territorial boundaries of India. It's a different ballgame altogether that the IT rules and the IT Act actually assume extraterritorial jurisdiction, so long as we see the provisions of Section 1 and Section 75 of the Information Technology Act. But the last 23 years of the existence of the Information Technology Act 2000 has showed us that it's very difficult to go ahead and enforce or implement your extraterritorial jurisdiction. So there could be a large number of cases where information about government or governmental projects of India could be published by state or non-state actors located outside the territorial boundaries of India. And even if the said information is so designated as fake information or false information, there's no clarity or guarantee as to whether, how, and in which particular manner the said so-called declared fake information is going to be removed. Because if the service provider does not have any operation in India, he will not be even inclined to move in that particular direction. So we are practically going to be seeing huge challenges in the actual implementation of this entire ecosystem pertaining to fact-checking units. Let's quickly realize that internet is a paradigm which is full of falsity, full of fake information about forged information and false information. In a scenario like this, if you're only having a fact-checking unit whose only job is to go ahead and find out the inaccuracies in government-related data or government-related reporting, the idea may be just to give more clarity vis-a-vis the governmental perspective. But ultimately, it tends to throw up far more different questions from a global legal and global community standards point of view. To say, look, is it a step towards censorship? Is it a step that is in sync with the Indian democratic traditions? Now, those are questions that are getting, asked in different parts of the world. It's still very early to go ahead and comment on how the said fact-checking unit is going to evolve. Let's see. I'm pretty hopeful that the government will come up with appropriate checks and balances so that the said fact-checking unit can be doing its work in a very restrictive and limited manner. And that said work should or ought not to go ahead and impede upon or violate the journalist's rights to freedom of speech and expression. Somewhere down the line, that golden balance will have to be met. Now, when and how and where we will go ahead and meet the golden balance is something that only time will be able to tell. And I also believe that this particular fact-checking unit has effectively rustled so many feathers that we could even potentially be seeing new legal actions or litigations or public interest litigations challenging this very factum before the courts of law in India. Well, let me clarify that when I read the updated amended IT rules 2021, what the rules tell me versus what the popular conception is, there's a disconnect. The popular conception is that everything under the sun will come under the ambit of the government, and they will be having the ability to designate just about any information as fake information or false information. But that's not what the specific language of the updated rules are saying. The updated rules are only giving a limited mandate to the fact-checking unit only to classify or declare any information to be inaccurate or accurate, depending upon which information has got a connection, association, or nexus with the business of the government or its various agencies. So it's only vis-a-vis governmental information that the fact-checking unit is going to go ahead and operate. So it's not that any private information which gets generated by any private entity pertaining to private citizens or private legal entities that will be adjudicated as fake or false. That's not going to be happening because that's not the remit of what is the specific language that's been used for the said fact-checking unit. But even because the government is the biggest litigator in the country, the government has become the biggest collector of data in India, and the government is also the biggest data repository in the country. It therefore becomes important that even when you look at the fact-checking processes pertaining to governmental information, there must be adequate transparency, there must be adequate accountability, and there must be adequate advance notice to everyone as to what will be the parameters that are going to be potentially kept in mind or relied upon by the said fact-checking unit for the purposes of coming to a conclusion whether any governmental information is a fake or not. Well, it can even be said that when you are an investigative journalist and you're investigating something which shows something which is in contravention of the law, it could be possible that your information, till such time it's not independently verified or authenticated before court of law, could be so designated as fake information, because that could be not within the parameters of what's going to be stipulated by the fact-checking unit. Therefore, I believe transparency and accountability becomes important mantras for this fact-checking unit per se. And if we have the best brains, the best professionals in this space as an integral part of the fact-checking unit, the increasing credibility of the fact-checking unit will be a very important factor, which will help enhance the comfort level of people. Look, at the end of the day, it's in everybody's interest, including the interest of every Indian, that no information pertaining to Indian government needs to be published, which is fake or false, or which could prejudicially impact the security, sovereignty, or integrity of India, or even Indian sovereign interests in cyberspace. So to that extent, there's no quarrel about the basic proposition. But the manner how you're going to go ahead and implement and enforce these fact-checking exercises is an area that requires much to be desired, and therefore a lot of work will have to be done. In fact, I think you need to have specific dedicated rules only to specify how this adjudication of the fact-checking unit by the government is going to take place, what will be the processes, what will be the procedures, are you going to give any advance notice to the concerned person who has generated the content? Would you give them an opportunity of being heard in terms of getting their version before you decide your version? Is it going to be ex parte that, look, they decide whether the said information is fake or not? Will any due process of law be followed? Will the rule of law be followed? Those are fundamental questions that are coming before every person's mind. And I think those questions would be definitely in the constitution of the government, as the government may come up now with new processes and procedures for elaborating the working and the implementation of the fact-checking unit. For the vast majority of the information industry, which is not dealing with governmental information, this rule will have no effect or no efficacy. Why? Because it's not dealing with private information. It's only dealing with governmental information. So only that component of the information industry that's dealing with governmental information will have to take an additional added precaution to ensure that whatever they are publishing, transmitting, or causing to be published or transmitted on their platforms is something that they have independently verified or authenticated, and that there are appropriate parameters for you to prove that the same is correct or inaccurate. Yes, any kinds of hypotheses, surmises, or conjectures will have to be completely avoided, because in case if your information is so designated as fake information by the government fact-checking unit, it could start having an impact upon the way how the governmental institutions will look at your respective portal or your services, but could also have an impact ultimately upon the reputational aspects of legal entities at large. So I think for a majority of the ecosystem of the information industry or the industry environment, where information is the name of the game, so long as your information has not got to do anything with the government, these rules will have no applicability.